leave petition, my.
What application? We have not filed an implement. Matter is pending since 2020.
My lord, in
Seems
the
you are
last,
not interested.
in the last occasion, my lord, this court says to file leave petition for
So
this.
why
matter.
should we have said you are not a party? You could not have filed an appeal
My lord,
without seeking
we are,
permission.
we are filing leave petition, my lord. We have
When?
already by tomorrow, my lord, we will file.
Counsel for the applicant. Raise for and is granted further opportunity of 2 weeks to move the requisite application. Leave application, rest after 2 weeks.
Oblige.
Yes.
May I please direction my senior Lex, Vice for timing.
Which matter, madam?
Item number 31.
31 is a mention. We are not calling out the matter as yet. When the matter comes up, you make a mention.
Item number 30, Lordship.
Hmm.
Any other day, Lordship.
Why?
That's what, because I could not take preparation because of sudden medical.
Can counsel for the petitioner raise for time to prepare and argue the matter? List up to 6 weeks. Yes, please.
My lord, I appear for the private respondent in the matter, my lord. May I pray for a shorter date, my lord?
Why?
Well, my license has been hanging fire, my lord. So I paid the money. They're challenging.
Is there a stay by this court?
There's no stay, my
Then
lord.
all
The
right.
authorities are not moving, my lord. Because of
List
the
up 4 weeks, 4 weeks. Part ka date dete.
Deeply obliged, my lord.
May I plead your lordship? May I plead your lordship? Your lordship, I beg to mention the PC number 1203 of 2022 for listing.
1203,
1203 of 2022.
22. What is the next date fixed by the office?
Not yet fixed, your lordship. I beg
Find
for
out,
listing of-
because pending matters, they can't be listed on mentioning. You have to just find out what is the matter, why the office has not listed it. Let us know. Pata kar le. Find out.
Daily list for orders, item 9. Item 9 to 11.
Amendment application has come. The cost title has been filed. Hmm? You appeared for the newly added respondent, National Council. You last date you said,
Transgender.
Your lordship.
you said that you will get the service
Yes,
affected.
your lordship, we have just received the dusty by today only. So I will just need only 2-3 days more.
But he would not be appearing for the council, we suppose.
Council lordship unless they request.
Yeah, so you'll have to get the land council for the petitioner submits that the notices for the Dasti service have been taken today and that service will be effected within 2 weeks
2 weeks.
or 3 weeks. List up 3 weeks
Alright.
for effecting service on the respondent number 2. Newly added respondent. So and so. What are the other matters about? They are
Your lordship in item number.
Item number 10 and 11, we are filing the affidavit today, my lord. I'll serve the copy now.
you're
In fact,
filing
we
the
have
affidavit
also filed an affidavit in reply.
already. But they have not served the affidavit as yet in anticipation. All right. Then counsel for the parties pray for and are granted 2 weeks time to complete the pleadings. All right. List up 2 weeks along with 52 of liquid 3 weeks. Kar dena.
Item number 13.
There was Mr. Nath. In this matter, that was the issue raised by current counsel regarding that maltreatment. We suppose you showed some pictures.
Yes.
Stripping.
That is.
What
that
have
is
you
what
said
we
in your
filed.
affidavit? Stripping in police stations.
No, in
That was probably
Yes,
what you brought to
your
notice.
lordship.
lordship, now lordship is taking up item 13.
All three are there before
No,
us.
then item 9 and 10.
Hmm.
Lord, in item 10 and 11, my lord, we have the address the
The
issue.
pictures they have shown, you need to issue a SOP,
Lordship.
proper SOP, how to
But the district cell and state cell that has been constituted, that we have brought on record. And
But-
that has been brought on record.
That has been addressed.
Your lordship, the sale which is constituted, that is not in accordance with what the NALSA talks about.
Hmm.
Because that has no any representation from the transgender community. Only the superior officers are sitting there to save their jobs. However, the rules is very much clear that there has to be a state level protection cell and district level protection cell to look out the various offenses and prosecutions. But in that case, how the police has got the right to
Have you
strike off the
got
cloth?
any details regarding what has been done in any other state?
Already, many of the state has done. Recently, the Rajasthan has came out with such.
Can you?
Yes, I will
keep on
produce.
record?
I will produce.
List after 3 weeks.
Lordship, whatever
Date
is,
kar dena.
whatever is available with us, we have submitted.
All right.
We are open, my lord. We have to.
These things
we have
need to keep on improving.
Correct, my lord. Correct. We'll
Nothing
definitely-
adversarial about this
Correct,
litigation.
my lord. Lordship.
It's everyone's responsibility.
Correct, my lord.
But
Renotify.
striping of a cloth is a very much gross negligence and violation of the human.
That is a violation, definitely. But the problem is nowadays people are they are misrepresenting themselves as transgenders. That complaint is coming. So what is the way out?
In that regard, a proper committee is required to be
So
constituted.
that's what we hope that state will take care of the things.
Lordship.
Renotify on 21st September.
My-
Date mat karna. Date hi dal dena.
Lordship
3
has
weeks.
fixed about 3 weeks, my lord.
21st September.
20.
That will be 3 weeks.
Month. Lordship.
Item number 13.
12. अच्छा, दे दिया. ठीक है.
Order
Okay.
was amended. Order was amended.
Would not order was.
Well, these proceedings were closed with on an assurance that necessary steps would be taken. Now, a note has come up, my lord, that steps have not been taken. That's why, my lord, it has been revived. In terms of order dated 3/1/23, madam.
Yes. Acha.
Yes.
Well, well, I in fact missed the matter. My friend informed me, Lord. Lordship, give me some time, Lord, so that I can have the up-to-date position. So far,
You have filed a reviving note.
The persons,
Registry,
they
person
have,
concerned.
they have filed a reviving. note.
The matter comes up before this court in pursuance of the reviving note submitted by the aggrieved person taking recourse to the liberty granted in the order dated 3rd January 23, whereby this suo motu PIL was closed. Mr. Nath prays for and is granted short opportunity to responding to the submissions made in the revival note. Renotify on 13th September.
Much obliged.
But, can I have?
Copy of the reviving note shall be provided to Mr. As well as the order dated 3rd January 23. That you will be having.
I have.
Reviving note shall be provided to Mr. Nath.
Item number 14 and 15.
Yes, what has happened?
My lord, on the last occasion, the respondents were directed to inform the court about the status of the NI cases with their under
Yes.
withdraw.
My lord, today has been fixed in the trial court below. As
Okay.
per the instruction I have received,
Mhm.
he is the husband, my lord, and now divorce has been granted. Now, as per the terms and conditions, my lord, as per the
So
part
you
of
have to
the,
ensure that the complaints are withdrawn, sir.
as a part of the alimony, my lord,
Mm.
that husband has already paid that particular amount.
Is nothing, no alimony. This is a misuse of checks, we can say, on the face of it. The lady never went to Punjab.
My lord,
How could the checks have been given to that person?
my lord, that's been a.
As a matter of fact, it is a fit case wherein the husband should have been prosecuted here for fraud.
No, my lord, here is a case wherein for that purpose, my lord, they have lost an affair. With regard to investigation has been done. Final report has been submitted. That husband
Doesn't
has nothing
matter.
to do.
You let us know what kind of alimony, why you are adjusting this amount in alimony?
No, apart from that, land has been there. Apart from 33
anyhow,
cases been filed.
When will you let us know about the fate of the complaints?
Let it come after, day after tomorrow, my lord.
All right, as jointly paid list on
My lord, on
24th,
25th, my lord, may I pay for 25th?
25th. All right.
Obliged, my lord.
Item 16.
None present. On merit, there is nothing in merits also. List up to 3 weeks.
Item number 17.
None present. List up to 2 weeks.
Item number 18.
Early hearing.
Application for early hearing.
What is the matter about? What is on merits?
Matter, the challenge the violations of subsection 4, 8, 10 and 12 of the section 7 of the Assam Cattle Preservation
Main
Act
file then.
2021.
Main file. What has happened in the main petition where the pleadings are complete?
Pleadings are complete, my lord, we fixed for hearing, but the matter was not listed, my lord.
It will come up in its own turn, sir. This is a 2022 matters.
Yes, my lord.
Hmm.
But there are
Uh,
only,
Matter comes up for orders on the application for early hearing. The early hearing of the writ petition number so and so. The petition has already been admitted, no?
yes, my lord.
The said writ petition has been. When was it admitted? It has not yet been admitted. It can't come up for hearing then. We find that the writ petition has not been admitted as yet. Thus, list the writ petition number 2495/2022 for admission on 24th. We'll admit it and then direct the hearing.
My
to take
lord,
place.
White order dated 21/6/2022. The matter was posted for hearing, my lord.
Maybe, but without the matter being admitted, can it come in the hearing capacity category, sir? In the interlocutory application is disposed of. First, it will be admitted and then we'll list it for hearing.
Item number 19.
This case relating to my lord, my lord, old new pension to old pension, my lord, similar already. Case.
Admitted.
And
Admit issue notice connect with so and so.
the one, read appeal 163 of 2023.
Service upon the respondents be taken by providing copies of the appeal to learned standing counsel concerned.
Along with my lord, 163 of 2020.
Not
Much.
Item number 20.
Yeah, lawsuit, my lord, the matter may be passed over for time being, my lord. My senior is in another court, my lord.
What is the matter about? Pass.
Item number 21.
Yes.
We have filed a rejoinder, your lordship, but
Yes. All right, proceed.
Your lordship, may I plead, I'm led by Mr. K. N. Chaudhary in this case. May I plead that the matter be passed over for a time being, your lordship,
All
for a
right,
time being.
pass for timing.
Lordship, may I submit, Lordship? In this case, my affidavit is already there. He has filed his reply. Let it come in the record, Lordship, and let me also go.
Your affidavit has not been brought on record.
My one is already there, Lordship.
Then
He is saying that he has filed his rejoinder. That.
When did
copy
you
is
file
not
it?
with me, Lord.
I had filed it, your lordship. On 6th of June 2023.
That copy is not with me, Lordship.
you not got a copy also?
No, Lord.
Then counsel for the petitioners as filed affidavit in reply
Yes, your lordship.
on 6 June 2023.
Yes, sir.
Copy thereof has not been provided to learned standing counsel, Mr. Nayak. Needful be done immediately.
Petition being on it, right?
Yeah, no, this one, this.
275.
Is the what again?
275.
It's simply a formal kind of affidavit. Anyhow, give a copy.
Yes, your lordship.
Copy thereof be provided to learned standing counsel, Mr. Nayak. The PIL is admitted. List for hearing. Hear it at leisure. It's a luxury litigation otherwise also
Give to your lordship.
in due course.
Item number 22 to 24.
Make your last.
Yes.
But in item number 23, we filed an affidavit. And if your lordship kindly peruses the order dated 22nd of June. My lord, in the affidavit, we had shown that the private respondent will not have the bid capacity to do the contract which has been awarded. And detailed affidavit and calculation has been filed, and the time was, my lord, asked for to file affidavit.
My lord, I have
Yes.
got the instruction, my lord. As per my instruction, the lead petitioner who is the respondent in the lead appeal, he has got the bid capacity. That's
He
my
has
instruction.
got the bid capacity. So please
Yeah.
place these facts on record by an affidavit.
By today,
You are already given the time on 9th August.
my lord, on 18th, I got the instruction. I will file it today itself, man.
Your standing counsel, Mr. Gogoi submits that he has received instructions and would be filing the affidavit within during course of the day,
By today, sir, I will file that.
during the course of the day. Re-notify after 10 days.
All right.
The both will go together.
My lord, same
Three
issue,
together,
same.
my lord. In, my lord.
All three of them. Yes.
Item number 25.
Yes, please. Zakir. Footprints. What is this nonsense? Thoda sanitizer मांगा के ऊपर. What is this supposed to be? क्या चीज है? चलिए नहीं. Yes.
Lordship, last time when the matter was called for, Lordship, we.
Record.
Record,
Yes.
Lordship, records, Lordship, we haven't received. So another 1 week time will be required, Lordship.
So we never directed record to be summoned.
Yes, Lordship, it is not there on the,
Then?
on the records, Lordship, but it was suggested that records may be required because how the process was taken up, how the agreements, which of the agreements contents and all those things are not there before your Lordship. So that's why. Lordship-
Who has moved this application opposing the transfer to the principal bench? You filed the application. There is some application for opposing the transfer. Who has filed that application? Conducting counsel. You moved the application for transfer to this court.
Yes,
The matter was transferred on your request.
yes, Lordship.
So there is some reconsider. All right. So you need records.
I need the records, Lordship.
What is the matter about? Can you let us
And
know?
one more issue, Lordship, which is involved here. What they are seeking for is like since it was not done as per the land acquisition 1894.
Mhm.
Now, since like 2013 Act has come,
Mhm.
they should be considered under 2013 Act. But Lordship, there is a matter pending before this honorable court only, where the issue is, Lordship, what has happened is like 2013 Act has come, it's a central act. But Lordship, by virtue of Article 371G 371G is specifically for the state of Mizoram. And like Mizoram government has not adopted that particular central act.
2013 Act has not been
Has not
adopted.
been adopted. In fact, they have come up with another legislation in 2016. So
Okay.
that issue is still pending before.
But what is the date of the acquisition in this matter?
Lordship?
When was the acquisition made?
2010, Lordship.
10 or 16 Act would not save the things. No?
2013.
Neither
also-
2013 nor 2016.
Correct, Lordship, correct, Lordship.
But
That-
if the acquisition has not been done as per the Act of 1894, then they have a case.
Lordship,
That is what you have to
Lordship,
answer.
They have a case, Lordship, that I do not deny, but like Lordship, that for the state stand is also that Lordship, in 3 petitions, Lordship, 2 petitions, Lordship, 2 petitions, those landowners, like what they are claiming as a landowners, they do not have a single document of.
That
owning
is a
any land.
different
Nothing,
thing.
Lordship.
That's a different thing.
Nothing.
It can also be by the occupier, you understand,
That's-
not only the owner.
That's true.
So anyhow, why do you need the records for? What is the
Lordship,
reason?
because we want,
Pleadings are already there.
like, how, like, Lordship, that acquisition has been made and how the money has been paid. I mean, what is the process they have taken up, Lordship?
Is
That's
it
what-
not incorporated in the pleadings?
It's not there, Lordship, there is already. So Lordship, may give me 1 week time, Lordship.
They need time to procure the record, original record. Should we grant them time?
Let us be fair, Lordship, but next time, let there be hearing. And let there be.
We are ready to hear it right now, but he is pleading difficulty on the ground that he doesn't have the original record.
It has cost me time and money and causing this kind of excuses.
Why don't you address the court by VC from Aizol? We have facilities.
But that is the right, Lordship. I want to meet Lordship personally.
Then all right, come once more.
Yes, Lordship.
Okay, very well. Mr.
Please give
Kalita,
us a 12.
12th September.
Yes.
All right, Ms. Kalita, Additional Advocate General, Ms. Kalita,
Is it
submits
convenient?
that he has not received the original record
Yes, sir.
and is hindered in addressing the court in absence thereof. In the interest of justice, we grant one more opportunity to Mr. Kalita for procuring the original record. We make it clear that as the learned counsel for the petitioner comes from Aizol to argue these matters, we make it clear that no further opportunity shall be granted on this count.
12, Lordship, 12.
List on 12th September as paid.
Publish it.
All 3. Ms. Chaudhary, you don't need time, na?
Lordship, in fact, I am the executing agency, so,
Okay.
but my instructions have also not come. I will press them, Lordship.
Mr. Deputy SJ, Mr. Chaudhary, to complete his instructions in the meantime.
Lordship.
You can inform learned counsel in advance. He has to travel down.
Yes, Lordship, it was supposed to reach yesterday only, then I got a call, then I could.
Be fair to him. Yeah, both will go. Both will go. With कर दीजिए ना इनको. All these 3 writ appeals, which involve common questions of facts and law, are tagged and shall be listed together on 12th.
Item number 27.
27 also same. 25, 26, 27.
Item number 28.
Yes, please, Lordship. Lordship, our affidavit will be filed during the course of the day.
What is the matter about?
I have challenged rule, my lord.
All right. The affidavit on behalf of the respondents. Learned counsel, Mr. Bodloi submit that the affidavit will be filed during the course of the day. The petitioner's counsel may file affidavit in reply if so desired by the next date of listing, re-notify on 21st September.
Item number 29.
Please, the Lordship, as per Lordship's direction, we have filed affidavit, Lordship. By bringing
You have filed affidavit.
Lordship.
What is the matter about?
Matter regarding Lordship, financial irregularities, they have sought for Lordship inquiry. As per Lordship's oral observation, Lordship, we have constituted a committee, Lordship. A committee has also submitted the report, Lordship, that was annexed in our affidavit, Lordship.
Report is already there.
Lordship.
What is the committee appointed?
Committee appointed, Lordship, the persons who's against, they have sought the inquiry, Lordship. He is not in that period, he is not in the service in that period, Lordship, in such principal, Lordship. Another one is indicated, Lordship. In paragraph 4 in our affidavit, we have stated lordship.
Affidavit has been filed on behalf of the Higher Education Department. None present to argue the matter on behalf of the petitioner. List of 4 weeks.
Oblige lordship.
Item 31,
May I plead your lordship?
Yes,
Lordship, I have challenged the order of detention, lordship.
yes, please.
That is at page 17, lordship.
Delay in execution, that is the only ground.
Delay in execution, lordship.
What apart from that? That is no ground. We
It is
told you last date.
Another ground is, lordship, criminal cases are pending, lordship, that is trial is going on, lordship.
So that can't be a ground to quash the order of detention.
Because
That shows his conduct.
otherwise, lordship, there is no allegation that he had violated the bail condition or
That is not a ground. Your repeated indulging in narcotic cases, that is a sufficient cause to detain.
yes.
You will find not one, even a single case can form the basis of a detention order. So, all right, argue, madam, what do you want to say?
Except that I have not found any judgment, lordship. Last occasion I prayed for, that's why.
We gave you time, you could not find,
Yes,
we
yes.
told you other day also.
Yes, lordship.
This
I
delay is
tried.
hardly anything.
Yes, I tried, but no.
So then, all right, we'll close the petition then.
Obliged.
All right. Yes, madam, what do you say?
Yes, my lord, we have filed our affidavit in page number 75, my lord.
Delay, how much is the delay in execution? How have you
Lordship,
justified?
From the date of order, 1 month, 18 days, lordship. And from the date of proposal, lordship, 3 months, lordship.
Proposal is not relevant.
Yes, lordship. But I have placed one judgment last occasion, lordship. Here, lordship, 5 months from the date of proposal. On that ground, lordship, that order was set aside, lordship.
Yes,
Paragraph, lordship, 20,
we will examine that judgment also.
paragraph 20, lordship.
Yes. In that case, there were significant other grounds also.
That lordship, they are also criminal cases are pending. lordship.
Criminal cases are pending. In that case, the authority was not cognizant of the fact that the detainee had been released on bail.
Exactly, lordship.
That was a non-application of mind,
Exactly, lordship.
which
That
is
was-
not there. In the present case, the order
Yes,
refers to that
Yes.
fact that he was released on bail.
yes, both. the
Okay,
cases.
very well. Thank you. Dismiss.
Obliged.
pass over matter 20,
Yes, please.
May I please, your lordship, and here in this case, my lord, the case of the petition was rejected by the honored single judge that he has submitted the application after 19 years. This is a compassionate appointment, my lord. Since at the time of fact, my lord, petitioner, father of the petitioner in the year 1990, petitioner was minor, my lord.
Yes.
So he could not file the on time, my lord, but his mother has applied, my lord. In 1994, my lord, same has not been considered. After attaining majority, petitioner submitted the application, my lord. After attaining majority.
We understand. You see, compassionate appointment is not a matter of right.
My lord.
It is a measure of providing solace to the family from immediate financial distress
My lord.
and penury. So if you manage to survive for no good, no less than almost 20 years,
My lord.
then what is the penury? What is the financial distress? You must have, your mother had a occasion to challenge the non-consideration of her case. Why didn't she wake up?
In fact, my lord, she has, my lord. She did not approach this honorable court, any other authority, my lord. Since being they are not in a position, my lord.
No, that can't be an argument.
My lord.
They have been
And-
surviving, the terminal benefits must have been given. What were the terminal benefits after death of the employee?
My lord, in this respect, my lord, I have also annexed the honorable single judge judgment, my lord. In another case, my lord, at page 46, your lordship may found, my lord. In
46. Let
paragraph
us-
5, my lord.
Hmm,
The provision,
hmm.
provision of avoiding late submission of application, my lord, is on the principle that if the family could survive for a particular period of time, there is also a corresponding presumption that the family does not need any further compassionate appointment. The said principle is correct if it is looked from the particular point of view. But again, further question would remain as to in what manner the family survived for the intervening period in the circumstances where no competent person was able for seeking compassionate appointment for the intervening period. From such point of view, we remand the matter back to.
In this case, sir, it is not the fact that the mother, the wife of the employee had applied. In the present case, the wife applied, then she did not pursue. So there is a presumption that she did not have any financial distress. You understand? Rejected. Thank you.
Top of the list matters. Item 1 to 3.
Yes, please.
This state act is being challenged in all these three cases. The virus of the act has been challenged.
Mr. Nair, would the promulgation of the Right to Education Act not make any difference?
Here. No,
Yes.
my lord, that has already been dealt with. And whatever is to be done under the RT Act, that we are doing, my lord.
Okay, very well.
This is, my lord, a separate control, a further control being made on these schools. my lord.
All right.
So my lord, my three grounds, my lord, I will hand over. Item number 2, your lordship may.
My lord, we'll take
Where
item number-
pleadings are in item number 1, writ number 119.
Yes, my lord, item number 2,
199, yes.
2806.
2806, my lord.
199 also pleadings are there.
That is that.
Yes.
So my lord,
Who represents in 199? There are 4 matters connected together. Yes, the matter should not be stuck up because counsel are not there in 1 or 2 matters.
no, my lord.
The other two matters, my lord, takes up, my lord, this will also.
Mr. Nair, the counsel have to be here. Otherwise, one may complain, you are not heard. Item number, you are in item number
I am in item number 1.
1.
My
So
senior-
all Assam.
all
Mr.
Assam.
Borbora is in item number 2.
2.
Who is there in item number 3
Mr. M.
and item number 4?
3. 4 is a different matter, my lord.
No, 4 is a different matter.
4 is a different.
Item number 3.
3, my lord.
Mr. M. Kataki,
Kataki.
please send a message.
I'll-
You should be here. Yes. All right.
Should I start, my lord?
Yes, please.
My lord, on 3 counts, my lord, I am basically challenging this. 1, my lord, repugnancy. Secondly, my lord, the act which is under challenged contains provisions, my lord. Some of the sections are, my lord, self-contradictory, and some of the sections are contradictory to the other sections. Thereby, the act will be, my lord, ultra-virus and both intra-virus.
All right. Let's see.
And thirdly, my lord, in the name of, my lord, regulating the non-government schools of Assam, the act, my lord, it has virtually taken over the entire management of the schools. My lord, these will be the 3, my lord, grounds on which, my lord, I'll endeavor to convince this honorable court.
Yes.
My lord, I am a school. It is a-
Before you proceed further, Mr. Borbora,
Lordship,
similar acts have been promulgated in different states. Any challenge laid anywhere else?
I am not aware of that, my lord.
Very well.
I am not aware of that. Mother, maybe in, my lord, different languages and different, my lord, contents about, my lord, regulating schools. Here, my
Yes.
lord, it is all pervading. My lord, this is a DPS school, my lord, Delhi Public School. Lordship knows it is a chain. It is in the, my lord, NRL, Numaligarh Refinery Limited, and it was set up in 1997 with the finance from the NRL, which is a, my lord, state public sector undertaking. my lord. So,
So the pervasive control of the state is already there
yes,
because the finance is by the state.
finance is by the, set up by NRL. It is known
Yes.
for its, my lord, good academic results and best infrastructures provided to the schools as opposed to the existing, my lord, government schools, my lord. This school is also affiliated to CBSE and which conducts and manages, my lord, secondary education in the country and under the aegis of the Ministry of Human Resources. And CBSE is the second oldest board of the country, set up in 1929, my lord.
Yes.
And there are more than 10,000 schools, both in India and in some other South Asian countries, also in African countries. It has got its own bylaws, prescribing, my lord, in detail, my lord, all aspects of management, appointment of teachers and staff, disciplinary proceedings against teachers and staff, and then, my lord, fee structure, and, my lord, the constitution of the management committee, the nature and function of the management committee,
Yes, please.
my lord, A to Z for last so many years. And
Yes.
the manner and method of constituting management committee and their nature of function, all prescribed. Now, my grounds of challenge are primarily, my lord, I'll refer to the act and the rules in a while. Education being an item in the concurrent list, my lord, entry
Yes.
25, both the union and state legislature have the power to legislate. Here, my lord, in presence of CBSE's own bylaws applicable to all its schools all over the country, with the overall control being with the Ministry of Human Resources, Lordship will see to what extent the overlapping and transgressional actions or
CBSE is a party in these writ petitions.
Yes.
Who represents CBSE?
My
You
lord,
are there,
CBSE
madam?
is there. Yeah.
Okay.
They have filed an affidavit also. That is in my support. To what extent overlapping transgressional supervision control are sought to be inflicted, my lord.
Yes, please.
Lordship, may kindly have a look at Article 254(2) of the Constitution. Edana.
Yes, please.
Article 254, who will be important. I am reading one also. Inconsistency between laws made by Parliament and legislature. If any provision of a law made by the legislature of a state is repugnant to any provision of law made by Parliament, which Parliament is competent to enact, or, my lord, here I emphasize, or to any provision of an existing law with respect to one or two, one of the matters enumerated in the concurrent list, then subject to the provisions of clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or as the state may be, the existing law. This, my lord, existing law, I again emphasize, for reasons I'll tell, my lord. And the law made by legislature and state to the extent of repugnancy be void. Now coming to 2, my lord. 2 will be very relevant for this, my limb of submission, my lord. Where a law made by legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament, or, here emphasize, an existing law with respect to the matter, then the laws are made by the legislature or such state shall, if it has been reserved for the consideration of the president and has approved, has his assent, prevail in that state. It means that if there is an existing law with respect to the matter, then the law made by, still there can be a law made by the state legislature, can be made by the state legislature, but it must have presidential assent. Now, my lord, lordship, existing law, and what is law and existing law under the Constitution, lordship, may kindly turn to Article 13. It is in the part 3 of the Constitution, Article 13.
Yes, please.
Lordship may come to 3. 3A. The state shall not make any law. 2, I am reading 3. In this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, emphasis, rule,
The heading-
regulation, notification.
Please read the heading of the article also.
My lord, laws inconsistent with the or derogation of the fundamental rights.
How does this Article 13 help us?
My lord, to set up a school, P.N. Pai's case, it has been clearly said by Supreme Court that to set up or to open a school is a fundamental right. That's why I come. That's where I come from, my lord.
Okay.
Therefore, my lord, the law includes any ordinance, order, or bylaw, rule, regulation, notification, even custom and usage. Therefore, my lord, I respectfully submit that first prima facie question first in this case. Lordship may kindly turn to the gazette notification of the act impugned here at page 31.
Is 31.
Page 31, I have the impugned act is, my lord, I have annexed the gazette notification.
Yes. Yes.
My lord,
We'll take it.
page, so page. Yes. Page 31.
Yes.
The following act of Assam State Legislative Assembly, which received the assent of the governor, is hereby published for general information. It needs my lord presidential assent because it is a matter of list 3. Therefore, having not taken any presidential assent, this will be my first submission, my lord. Apparently, it has not received presidential sanction.
Okay.
And we have the bylaws. I think that is there. It is a very comprehensive bylaws. It, my lord, it is Board of Secondary Education affiliation bylaws. It not only affiliation of the CBI's of its schools, its managements, the appointments of teachers, the disciplinary proceedings, the fee structure, everything is provided, my lord, in this bylaw. And all CBSE schools are governed mandatorily by the bylaws of the CBSE.
Yes.
So,
Yes, please.
now, my lord, irrespective of the question, whether act is whether this act is vitiated by not getting the presidential assent or not, even otherwise, I will submit that the various provisions, I will read, my lord, a few of them initially. They are not by themselves contradictory. It's not sure whether some provisions are mandatorily required, mandatory or directory, and some sections are contradictory to the other sections. Lordship may kindly turn to page 32.
Yes.
Here, my lord, the preamble states to regulate the establishment and management of non-government educational institution in the state of Assam. Whereas it is expedient to regulate establishment and management of non-government educational institution in the state for matters connected therewith, incidental thereto. Fine. Now, my lord, the 2G below. What is non-government educational institute? Non-government educational institutions means schools or junior colleges established and run by an individual or association of individuals or any non-government organization or society or trust, except the schools established and maintained by minorities under 30A, Constitution of India. So this may be segregated, except the schools establishment, Constitution of India, and imparting education at primary, middle, secondary, higher secondary levels without receiving any grant in aid from the state government. We don't. Excluding, again, my lord, this word, excluding the educational institution run or aided by central government or
the
state government.
Yes.
I, my lord, let me read. I actually read it again and again. It's very clumsy, my lord, the languages.
Indication is that those institutions which receive grant in aid or finance from the state government or the central government, they would be beyond the purview of this act.
Excluded.
That is what the idea.
State cannot control, as per my lord, the Father Thomas and Maharashtra, the minorities, that is different thing. So for schools like ours, CBSE schools, and my lord, DPSE schools, for that matter, my lord, Kendriya Vidyalaya. We are these sorts of school, my lord. So the word excluding actually covers. We are not private funded. We are set up and funded by central public sector undertaking. We are not private funded. Actually, we are excluded. And normally,
So if, Mr. Borbora, if you are excluded, why you are bothered by the provisions of the act?
that's right. That is precisely the question, my lord.
If you are,
Normally,
you consider yourself to be beyond the
so normally we shouldn't have
operation
any,
of that, why you are required to challenge?
so normally reading this, we shouldn't have any grievance against the state.
The
But
simple
for-
mandamus should be set, so that we are not controlled by this act.
I'm replying to
So
that.
we
But
give
for-
that direction.
normally, we would not have any grievance. By the word, by the word excluded, we are excluded, but because of the assertion made by the director in his affidavit, that it applies to our school also. I'll refer to my lord, that
So
affidavit,
then
my
it is
lord,
a matter of interpretation of this act itself,
Yeah.
not a challenge to the virus.
yes.
Whether the act applies to you or not. That is a simple question. Why does it come to division bench then?
What's it?
Why does it come to division bench then?
My lord, any act, my lord, I must give a notice to the Advocate General, my lord, and then it
Mr.
comes.
Borbora, you are arguing that your institution in individuality as an individual institution is not governed by the provisions of this act.
Yes.
If upon reading the provisions of section 2G.
Yes,
So why is it a challenge to the validity of the act?
because my lord, the director secondary.
So that is an action of the director you are challenging. That is a writ of mandamus or certiorari you are claiming. That the director is wrong in saying that this act applies to my school.
Yes, director-
That is the simple argument which you are raising.
That's right.
So why we are required to go into the validity of the act?
No, my lord, because they were issuing notices, no?
Let us see your prayer, please.
Notices. Huh? Because
Let
they
us
were
see your
issuing-
prayer.
They were issuing notices. Prayer, Lord. My prayer.
Prayer is to the validity. You never raise any grievance that the director is wrong in saying that this act applies to your school because you are excluded by virtue of 2G.
Director
That's
is-
not your ground. Is it any part of your pleadings?
Yes,
Let's see.
yes, my lord. I'm sorry. Paragraph 10 and 11, my lord. I have said,
Yes,
and my lord, the director's affidavit is at
we'll read that. Yes.
paragraph 6 of the Director Secondary Education, my lord, 10/12/2012 affidavit.
Page.
10/12/2012 affidavit. My lord, when the matter was being heard at the admission stage, at that time, my lord itself, it was filed.
Where is the affidavit, please?
Page, my lord.
And before proceeding further, Mr.
Yes,
Borbora,
yes.
what has been done by the state authorities which has given rise to this apprehension
Page 6, paragraph 6
of
of this affidavit, my lord.
your affidavit or the director's affidavit?
Director's affidavit in opposition.
Oh, we understand that affidavit has come around after the writ was filed. Before that, what happened, which gave rise to this apprehension?
Before that,
What was the order passed or any action taken?
actually,
We were asked to register
oh, we were asked to register, master,
under the act.
under the act.
Okay.
We
Where
were
is that notice?
We are asked to.
Well, that notices have not come on record, but there was continuous pressure because this case, the 189 was immediately filed, my lord, thereafter. And there was an order of status quo. So, my lord, the
We
matters
understand,
remained
but-
as such.
You know, this can't be an anticipatory bail application without FIR. So where is that notice?
My lord, in my senior's case, there is one school involved. That is the DPS, which is, my lord, monitored by the, was set up by the NRL.
Yes.
By an agreement between.
Mm.
In the other cases, my lord, those are private schools set up by societies or, my lord, individuals.
Mm.
Therein, my lord, we are required to
so-
register.
That's a different category of litigation.
Lord.
So far as this school is concerned, if they are arguing that we, by virtue of 2G, we are out of the purview of that, then that is a simple prayer.
No,
Sir, where is the notice?
No, no,
to register.
notices have not. come in
Then
that case.
why a writ petition in mere
Because, my lord,
apprehension?
The act that was there were paper notifications also requiring us to all to go and, my lord, register ourselves under that act. That is how, my lord, this has come.
There
There is no written notice, my
There is
lord,
no
but
notice.
there were, my lord, pressures being put up on all these schools.
And
Mr.
At
Nair,
that point of
we don't expect this kind of argument
No, no,
coming
no,
from
my lord,
you.
I'm not on that. I'm not on
Then-
that. This
then-
school, my lord, if my lord says on item number 2G, my lord, that school is excluded. My lord, that would serve the purpose, my lord.
If your lordship observe that, that will
That
stop.
will
But there were general,
Yes,
there was a
Mr.
sweeping
Nair.
advertisement in the
Mr.
newspaper.
Mazumdar,
Media,
the
like-
school, yes.
That aspect, my lord, I'll have to,
That is the fundamental aspect which is there on the face of it,
I'll have to confirm.
because your definition is very confusing, we can say. It mixes up the
Once-
minority educational institutions and then state-run educational institutions,
It does.
financed educational institutions with no clarity. And then it gives a discretion in 3 may. So may, who decides that may? Hmm?
This aspect, I'll have to have a.
Items listed at serial number 1, Mr.
And
Mazumdar.
This is something, my lord, which we were not.
This is the first argument which was bound to come. All right, forget about that. Let's hear the other petitions then. Wherein the challenge is given to the validity.
My lord.
Let's hear those then.
My lord, but the learned he would reply tomorrow, my lord. If they complete their arguments today, we are not taking time on that ground.
All right, very well,
If I
very
reply
well.
tomorrow, my lord.
Okay.
That is all I.
Yes, Ms.
They take the
Borbora.
arguments, I'll take a note, we'll reply to you.
Mr. Borbora, we'll seek his response to this argument
Yes.
tomorrow.
Yes, my lord.
But we are hearing the other matters right now.
He is in both the cases.
Yeah.
My cases also.
Yes.
And
So the validity part, the purely private educational institutions, they have a cause for grievance.
Look.
So let us hear them first. Your argument closes at that.
No, there I am also there.
All right, you are also there, then argue.
It's the same gazette notification lordship may take for a while.
Very
Lordship
well.
may hear Mr. Nair,
Okay.
same gazette notification. That question I understood, which you are pertinently raised by your lordship.
So
If
we have
they-
not raised the question.
If they say that we are excluded,
Hmm.
why should I be here? So
Yes.
far as DPS and CBSE schools are concerned. Lordship, kindly, I kindly have a look at certain sections, my lord.
Hmm.
2G I have shown
Yes.
excluding. Then kindly come to section 3(1).
Hmm.
Section 3(1). In all the cases, this act is challenged after all.
Hmm.
The state government may regulate all the non-government educational institutions in the state of Assam in accordance
Hmm.
with the provisions of the, it is directory, my lord.
Hmm.
It is not mandatory.
All right.
So, right,
This government may decide,
government, will-
identify the particular institution.
That's
That is
fine.
what the intent of the
that's fine.
section is.
I'm just pointing out. Then
Hmm.
2, on and
Hmm.
from the commencement of the date, establishment of non-government educational institution or the opening of a higher class or the closing down of an existing class in any existing non-government educational institution shall be subject to the provisions of Act.
Hmm.
Now, this is important.
Hmm.
And let me finish. And the rules made there under a non-government educational institution in any higher class established or open otherwise than in accordance with the provision shall not be recognized by so and so.
Hmm.
Now, my lord, we are a school, my lord, established some 25 years ago.
Hmm.
Not for us, my lord, running a school for more 25. We are not just newly setting up a school.
Hmm.
We set it up, my lord, way back in 1997. And it's a very overall, my lord, section, this is a very poorly drafted legislation. I may respectfully submit, my lord, vagueness in every section and every succession apparent and all part of things. Now, lordship, may kindly turn to section 6. Page 35.
Hmm.
The existing, like us, non-government educational institutions shall submit
Hmm.
application for registration of earlier they said may apply.
Hmm.
Here they are saying shall submit application for registration of the institutions before the director, furnishing full particulars, information, payment, such fees as may be prescribed relating to sought to be registered, and shall also furnish copies of government permission or recognition. This
Hmm.
is, my lord, I fail to understand.
Hmm.
If any previously
This
obtained
is
before
simply,
academic,
Mr. Borbora, this is simply to ensure that fair dealing is done to the students. At least the government has this information. They are only asking for information, nothing beyond that.
no,
And that information can only be
no,
brought in
there-
once there is a regulation or a registration system So you're registered and information is provided.
No, no,
That's all.
they're asking for many more things, my lord. Subsequently,
see.
I am coming to that, my lord.
Hmm.
And three,
Hmm.
immediately after provisional registration of an existing institution,
Hmm.
director shall make or cause to be made an inquiry or inspection of the respective institution and the existing institution which have been found, established, and run with the permission and recognition from the state or director possessing requirements as laid down under section 10 and the rules shall be granted final registration. Therefore, my lord, here in the first section, it says, after 6 months, everything will be invalidated, students and teachers, if we don't take the provisional registration. And after provisional registration, it is a new word, of an existing institution, director shall make or cause to make inquiry for final registration. My lord,
Inspection.
with provisional registration, certain schools have, my lord, 700, 800 students, and suddenly, my lord, you refuse to grant the final registration. Then everything will go haywire. Then, my lord, 5. The existing institution plus 5. Existing institutions which have been established or run without permission and recognition of state government director fulfilling requirements as laid down under section 10 and rules I'll come shall apply obtaining administrative recognition from the director. It was not mentioned, my lord, in section 6 at all. It is incidental. Administrative recognition. So if you want to state, my lord, mushrooming, frame laws about space, land area, my lord, student land area, ratio, buildings, etc. And don't go after, essentially because we are non-governmental schools, don't go after us. Then, my lord, administrative recognition committee. Here again, constitution of administrative recognition. The administrative recognition committee referred to under section 6. Actually, section 6 has not referred to any committee. Recognition committee. Section 6 referred to only director. Then these are the persons, my lord. So after 6 years of running, any CBSE school will have to obtain registration. Then we'll have to go under this administrative
Yes,
recognition
Mazumdar,
committee.
what have you said in your affidavit regarding Article 254(2)? He is absolutely silent. You will supplement by your arguments.
No, they have not been.
The AG will be making all his submissions.
You should have said it in the beginning. Where is the advocate general? He's not in town.
The assisting counsel, my lord, he had to move out of station due to some personal difficulty and I but we'll have it done tomorrow, my lord. There's no difficulty. I'll have every answer tomorrow, my lord. Just being-
Where is the answer in your affidavit, sir? 254(2), assent of the president in case of repugnancy.
In case there is a repugnancy.
So they are pleading that, they are showing
In
the
case there is a
repugnancy.
repugnancy, my lord, if we can show that there is no repugnancy, then that part would not come in.
All right, very well.
Then, my lord, section 12, page 38. Every non-government educational institution shall constitute a managing committee. Here they have. my
That is
lord,
just like SMDC,
Yes.
the government schools. That is all right, that is a salutary provision.
So by bylaw 20, it already provides, CBSE bylaw 20, it already
That is even
provides.
there in probably RT also.
Yes.
SMDC is there,
Yes. And
school
then, my lord,
management committee.
and then, my lord, lordship will kindly see 15(3), appointment and disciplinary matters. Even here, my lord, the state is taking over the control. Three, my lord, procedure to be followed in disciplinary matter, my lord, they have. So far as the other case CBSE is concerned, my lord, we have a detailed procedure in place, my lord. This is virtually governmental taking over. Then next page, my lord, 41.
No, 15 is not taking control, that is being transparent, that you issue a proper letter of appointment,
I'll come.
so that you are not able to exploit.
Come to section 41.
41.
Page 41.
Yes.
Section subsection 4, It talks about reservation, my lord. Who denies reservation, my lord? Supreme Court has already stated.
No, RTE
Then,
otherwise also.
yes. Then fee structure also modern school cases there, my lord. Here again, they have said one thing, provided that the managing committee with prior intimation to the director may invite voluntary contribution. We deny it. We discard it already. Okay, no capitation, no voluntary,
Capitation fees, yes.
no voluntary contribution. We have our own fee structure as per my lord modern school, my lord norms.
So you let us know what are the repugnant provisions.
Yes, then my lord, the most dangerous is section 20. Kindly see the power. Director or any officer authorized, maybe an inspector of schools. B, clause B, make such examination of place, building premises or inspect place, building premises, equipment, articles, documents, including financial transaction, and seize any of the such equipment, articles, documents without court's order. He can seize. There is the classroom, 50 computers, desktop.
No, before that, come to one.
Yes. See, I read it. Anytime the inspector of school may come and seize as many as 50 computers from a computer classroom without even a court's order. Unbridled power given.
Will you really be able to defend these provisions? Tomorrow, the Bar Council may lay down a rule entering into the advocate's office. Will you agree to that? What is this kind of intervention?
Some provisions mean, but then my lord, again, these whether they are
Better,
providing the
better,
necessary.
Mr. Mazumdar, with the coming into force of the RTE Act
My lord.
and looking to the amendments which have been made in these regulations, would the state government not be advised to take a fresh call on this?
What I find is there was an amendment in the year 2018.
Yes, on fees, my lord.
On the books also.
2000,
So there are some changes, my lord, the clauses which are referred to as.
They have been removed.
No, I've not removed, my lord. I have not. I did
You've
not
got the
see-
2018 amendments. Where are those?
Just look at it, my lord.
That is
No, I
regarding
have not
fees.
gone through everything, my lord. I've just seen that there is some amendment.
With regard to fee, they can. The Supreme Court decisions have also said,
Yes.
and there are two, there is an act and a rule for that also. The problem is in those act and rule, they define the institution to be a non-governmental institution in relation to this. Now, my lord, in addition to what my senior has said, the other, one more step would be there. These schools are already controlled, my lord. One by CBSE, through their
CBSE
regulations.
or the state board as the case may be.
State board, and there are two boards, one here, SEBA, matriculation, and the Higher Secondary Education Council. And these two are under two separate acts of the government.
Yes.
The government is controlling the institutions. Now they want, my lord, the director to come in. He has not been able to manage his schools. Now they are trying to manage our schools, my lord.
That
And this is
question
what
we were like, we were desirous of putting to Mr. Nayak. All right, we give the state control of all the private institutions. Will you be able to post teachers there?
Go further, my lord, 21 section.
You need to take a decision, Mr. Nayak. This much of intervention in private affairs. All right, welfare of students, we understand. You can lay down guidelines.
Yes.
And you can give consequences of non-following of the guidelines. But the control, pervasive control, then all right, perform your obligation as a welfare state, give proper education to every student. Then you will not need private institutions.
my lord, our institutions are required to give 25% seats to weaker sections. That, my lord, we are being forced, but the state has a corresponding duty to, my lord, pay that amount to us. They never do that. Majority schools, DPS and all, they run, there is no problem. But, my lord, there are maximum schools which are budget schools, my lord. 25% of their income being taken away, it's difficult to run, my lord. That aspect they don't look into.
And,
RTE Act again.
and section
All right,
20,
please let him complete. Yes,
section 21.
yes.
Money received or held on behalf of concerned non-government education shall be utilized for the purpose for which they are intended and shall be accounted for by the school authority in such manner as may prescribed. We have a very, my lord, strict network of, my lord, accounting and auditing.
Well,
By this CPS.
why the person is running a school for profit? What is wrong?
Who
If
decides?
the
Who decides?
operator say that I'll draw profit from the school, who are you to stop?
We get, my lord, who are you? We get
It's a
money
commercial
from.
venture.
This is regularly audited, my lord. We have a mechanism of audit and accounting, my lord. All right, fees, my lord, there, we are bound by the fee structure. We cannot be exorbitant. The surplus fund of every such institution shall be invested in such manner as may be prescribed and shall be utilized for educational development only. Then the accounts of the non-government educational institution shall be maintained and audit shall be done in such manner.
This has
as
been,
may-
the operation of the act has been stayed by this court.
Yes, madam.
There is a status quo.
Status quo.
Status quo.
In one of the,
In fact, whether any of the provisions are being applied,
My lord, some schools have registered, my lord.
have registered.
And some schools have registered.
Okay.
so they say that we will say in what manner you will have to do it. Then it says, next page, pilot page 42, institution shall furnish to the director an audited statement of accounts to the director, not accountant general, an audited statement of accounts at the closing of every. Then 24(1), where any non-government educational institution fails to fulfill or comply with the provisions.
So
of
in
Act-
effect, you have made the director to be the administrative head of all these schools.
Or any
Yeah,
other
at least-
officer nominated by him, like the inspector. of the-
All, at least manage your affairs properly. You're biting off too much, more than what you can chew. Is it right? All right. Yes, carry on, sir. Carry on.
24(1).
Hmm.
Where any non-government educational institution fails to fulfill or comply with provisions of the Act or violate any of the provisions, rules and thereunder, or any order passed by the state government or director under the provisions, the state government may at the time, after giving reasonable opportunity of being heard, order for withdrawal of administrative recognition and closing down of the non-government. After 40 years of running, one fine morning you close down 150 students. They don't even talk about closing it phase-wise. A batch will be there, my lord, in his 12th standard.
And
for
exclusion
the-
of the powers of the court,
Higher secondary students.
27. Exclusion of power of the court. No appeal. Does it talk of an appeal? You are making the schools
No,
remediless. The director is the supreme authority.
so my lord. And section 25, any non-government educational institution failing to comply with direction issued by the state government, director in discharge of their duties under this act, chairman, president, society, trust, individual, association of individuals, or any other person responsible for overall
Yes,
management
Yes.
or the owner thereof shall be held responsible and be liable to be punished with a fine which may extend to rupees 10,000 or offense in the event of commission of every subsequent offense may extend to rupees 50,000.
Which is the offense?
They now make it not my lord, manage for lack of management.
Yeah, Mr. Mazumdar, which is the offense? Let us know. Where is the offense defined? And what is the margin between an offending act and non-offending act? What is this act? What have you done?
The amendment at least gives us scope of an appeal at. section
Oh,
20.
so very graceful of you.
I'm just pointing out, my lord, I'm not saying. But my lord, then when on another occasion, my lord, when the schools were not giving the seats, 25% seats, my lord.
We understand, yes. So that is under the RTE Act. That is the right granted under the central law. They say, all right, central law is already there. But this kind of interference, meddling in the affairs,
Section 28,
yes.
page 43. The state
So,
government,
Section 27, Mr. Mazumdar, let us read 27. Except as expressly provided in this act, no decision or order made in excess of any power conferred shall be questioned in any civil court. So what is the otherwise? What is the otherwise provision? Which decision can be challenged?
The court, my lord.
Oh, why? A person having school in Gwalpada, why is supposed to rush to the High Court? Why not in the civil court? These are civil rights basically.
repressive, my lord, if I may use the word, repressive.
28,
28,
delegate
state
to
government, may-
any such other officer.
any other officer, my
You may
lord.
do it to a
So,
senior teacher in your school.
My lord, the delegation, my lord, powers not defined in my lord definitional clause section 2. Here it says state government may by order delegate any of the powers of the
An
director.
express provision has
So,
been made, sir.
so my lord, including the power to form opinion in vital matters. And power to seize, not only seize and all these things, power to form opinion. The inspector will form the opinion in vital matters, state policy of education. So, my lord, I respectfully submit, my lord, I am leaving it to Mr. Nair, my lord. These are
Yes.
all ultra virus. As I said, it is a very badly drafted legislation. Certain sections are not clear, contradict each
Any
other.
judgment you are citing, Ms. Barbara? All right, Mr. Come.
Ultra virus and intra virus, and my lord, it is not severable reading together. The act must go, my lord. And when the act goes, I needn't submit on the rules. We have challenged the rules also, my lord.
All
That is my submission. And about TNPI and other decisions, my lord. Actually, at 12 years old case, my lord, at that time, Nair was my junior, my lord. Therefore, still both of us are here.
Yes.
May I please, my lord? My lord has seen the scope of the provisions of the act, my lord. I'll not trouble your lordship with that. Now, basically, my lord, what I am trying to, my lord, urge before my lord is that 19(1)(g) gives us the right to establish these institutions. And my lord, the government has it under 19(2) to put in reasonable restrictions. Now, what would be the extent of that reasonable restrictions has already been decided by the case of TNPI, 11-judge bench of the court, wherein, my lord, the Supreme Court has laid down that there should be no interference with the internal affairs of the, my lord, school by the government. The affiliating bodies can do that, my lord.
Right.
With regard to fee, they can. They can have a body wherein, my lord, the school
Fee structure can be
school
regulated.
will prepare a fee structure, place it before that body, and that body, my lord, the appellate body also has a retired judge of this honorable court as one of its. Fine, my lord. There can be no dispute on that. But with regard to the management of the school and its day-to-day affairs, the director's interference, my lord, is an indirect interference in our right to exercise the power, the fundamental right under 19(1)(g). my lord. TMPI is clear to that extent. Now, my lord would have one provision, my lord, wherein, my lord, we have to go before the director. I'm just trying to show, my lord, how the act is not proper, my lord. My lord will have a section 14, my lord. In that only section 14(1).
Yes.
My lord will have these provisions, my lord, and my lord will think of the practical aspect. The managing committee shall frame a scheme of management of the institution containing the salary structures and other conditions of service of the employee, and the fee structure in all levels of education, amongst other things, as may be prescribed, and which shall not be inconsistent with the provisions of this act and rules made thereunder, and shall submit the same to the director for consideration, acceptance, and record. No levy of any kind of fee shall be made or imposed by the institution in excess of the fee as fixed in the scheme of management, except with the prior approval of the director. So, my lord, if I can go to the director, I'm a school, my lord, which is there with the act is to, my lord, see that there is no exploitation. I go to the director tomorrow, satisfy him that I had quoted 100, now I'm going to take 1,000. Where is that, my lord, that check and balance, my lord? The channelization of the act is not there, my lord.
The director can approve.
He approved, I take 1,000, my lord. Then what is the validity of this act? These provisions, my lord, now have been taken care of in the act wherein, my lord, they have framed for, my lord, fixing the fee scheme. Now, for that, we have to, my lord, give all the details of our school facilities.
Mr. Nair, would it not be better for the state government to reconsider the entire thing in light of the subsequent legislation?
Lordship, the only thing they got to do is, my lord, empower the bodies if required, my lord, those two acts, I'll just place those. If my lord can have the education manual, my lord.
What we do, Mr. Nair,
Lordship.
we'll, the Advocate General is to address.
Lordship.
Let it, you address the court on these aspects tomorrow.
Lordship.
We'll ask Mr. Advocate, Mr.
Lordship.
Satya
Lordship.
to respond.
Lordship.
And perhaps the state government itself can take a decision
I think so.
in a time-bound schedule.
Lordship.
Frame.
Because this act otherwise, my lord, is of no use.
Heard in part, Mr. Advocate General, Mr. Satya, is reportedly not available today. This list for further hearing tomorrow.
Tomorrow, much obliged.
Item number 4 and 5.
Right, with your lordship.
Yes, please.
But you kindly peruse the last order passed in this matter. The appellants have applied for the certified copies of the revenue records. And that they will giving an understanding that records were very old lying in the Mahapraskhana. They'll be taking about 2 weeks' time to get it. So records will establish our case, lordship.
Obviously.
So
You also get the records. There is no harm. What is the land recorded as in the revenue documents? So what is their status in the revenue record? Burial. So if it is reserved land, then how can we interfere? Then of course they have a right to do that. Of course, it can be regulated that the observation in the single bench's order that the water flows down, that can of course be directed to be regulated so that it doesn't cause any difficulty to the nearby residents. But then to stop them from using the burial ground as such, that will be infringing on their rights. But if it is recorded as a burial ground, sir, how can the land use be changed? That is the prima facie. You have the record with you.
No, I don't have.
Then-
We have said in the affidavit.
All right, Mr. Kotaki submits that the certified copies of the original revenue record have been asked for, have been applied for, and they expect that the same shall be provided within 2 weeks. Government Council is also directed to keep the revenue records pertaining to the 2 dark numbers in question available for the court's perusal on the next date. Re-notify
oblige.
on
To declare pollution.
28th September. Who is there for the applicant? There is one application by the residents. Anyhow, 28th.
That also be taken up at the same time. lordship. Oblige.
Item 6.
Hmm. Yes, yes.
I'll just recap my lord what transpired on the other day. The matter had in fact came on 21st April this year.
Yes.
And my lord, the matter relates to the release of water from the
Dam.
hydroelectric dam. Their case is that all of a sudden we have released the water, whereas our cases we have always informed, and there is a finding by the inquiry report made by the district judge pursuant to the lordship's order. And they say that the NEPCO has informed them much
The
in
state
advance.
authority, the affidavit by the state says otherwise.
Yes,
Okay.
but then my lord, there are 3 relief claims. One is directors to regulate the order, the water that we are already doing. Give early warning before the water is released, that we are doing.
Third is
Then the
compensation.
third is compensation. And as your lordship, my lord, has pointed out in the last occasion, compensation in 226, my lord, unless of course your lordships hear and find out, my lord, come to a conclusion that there was negligence.
Negligence, yes.
Then, so that was at that note, my lord, that day, my lord, the matter was concluded for that.
Yeah, we'll have a look at the report of the district judge.
Yes.
What are the conclusions?
My lord, your lordship may see at page 182, my lord.
They have objected. Who has filed the objection? You
My
have
lord,
also
we
filed. an
have filed because district judge, I'll just place that, in his finding after holding that we have followed all the decisions which were taken in the minutes dated 17/5/2018. And then he writes one line that NEPCO is not the only one who can be held responsible for negligence.
Let's
So
see.
only on that, your lordship may turn the relevant page is page 207. Findings. After considering the entire circumstances, I have found that the water level of river
Now,
Dhansari.
before that, can you come to 206, Mr. Commissioner?
My lord,
Bottom para.
my lord, the case, the cause
of the flood.
This one, my lord, the cause of flood. The cause of flood in the year 2018 at Golaghat district by no means is attributable to NEPCO, as it was happened due to natural phenomenon, and the NEPCO authorities cannot be blamed because they took all the precautionary measures and kept this district disaster management authority DDMA
informed well in advance all through.
Well in advance all throughout. After considering the entire circumstances, I have found that the water level of the Dhansari and Doyang was gradually increasing from 24/7/2018. Prior to 27/7/2018, some of the villagers were flooded with the river water. This was before we released the water. In the meantime, when the NEPCO authority released excess water above level 324 meter from the dam, from their dam since 5 AM of 27 till 5 AM of 28/7/2018, as a result, flood situation was deteriorated and the villagers lost their livestock and properties, including damage of their different cultivations. A newly constructed bridge was also swept away by the flood water. It is admitted fact that huge loss was incurred by the flood affected people. Regarding negligence of NEPCO, as alleged by the writ petitioner, I have found that the district administration Golaghat was alerted by NEPCO on 21/7/2018, 1 week in advance.
1 week.
1 week in advance, by WhatsApp messages. In the said messages, these messages are on record, we in fact given in our affidavit in opposition.
What is the response of the state authorities to your affidavit?
They have not adverted to that. And the petitioner has admitted that position in paragraph 5.
Who's there for the administration? You are there for the administration. So your affidavit, you say that NEPCO did not inform, but the report says otherwise. Have you? Okay.
So I'll let me just.
Now you have become wiser. Have you responded after this report?
Now, my lord, they are informing us.
Not now, at that point of time, the allegation.
Point of time, they did not inform. My lord,
They did not inform the report of the district judge is otherwise, that the information was given a week in advance. If that was so, and your authorities did not warn the villagers, who will be responsible to bear the brunt of the damages?
That also is mentioned here, madam.
Very well, carry on.
Let me place this. From the dam authority had been conveying the information through WhatsApp messages regarding rising of water level in the dam time to time. District administration was well acquainted with the next coming situation from 21/7/2018 onwards, but they did not take appropriate steps to evacuate the residents from the river bank side areas. As a result, flood situation deteriorated more. The water of the river was already rising condition due to rainwater, for which after release of excess water from the dam, it causes severe damage to the public and private properties, along with loss of livestock. Though the district administration has requested the NEPCO to keep the water in reservoir in some time, but it was not possible for them because that would cause major damage to the entire project as stated by the NEPCO authority. So considering the communication between the NEPCO and the Golaghat district administration since 21/7/2018, the NEPCO is not solely liable.
You are aggrieved by the word solely.
Yes, solely. We are not liable at all because if I will show your lordship the minutes. Because everybody knows there will be flood. It's a flood prone area. And even after 2018, this has not happened again. And first time it happened in 2018. But 2018, there was excessive rain and it
So
was natural. rain.
this plant is operative since?
There's 2000.
Since?
2000.
Okay.
2000. And first, it happened in 2018.
This warning
thereafter-
system must be in place since long.
Yes, yes.
Obviously, yes.
2000 only, my lord, it was. And this project was taken by the, after, my lord, the detailed project report was submitted by the Central Water Authority, CWC. And they are responsible, they have made, my lord, the height of the dam, the RWL, that is reservoir water level capacity, cannot exceed more than 324.
Obviously.
Once it crosses 324, my
The
lord,
water
there
has
is
to
no
be
way.
released. Water has to be released.
Yes, water has to be released, and we have been informing them. That is why, my lord, in the meeting of 17/5, if your lordship can just have a look at the
Page number.
my lord, I'll just, my lord. My lord, the writ petition, if your lordship will take it up.
14 lots of the writ petition.
Page 14 of the writ petition. Page 14, if my lord will see, they have annexed it in the writ petition.
Mileage the coordination meeting
Annexure.
for RD1
Yes.
and flood focus held on
The
17/5.
From where it starts, my lord, the decision taken in the meeting are as, then 1, 2, 3 is mentioned at page 14. The Golaghat District Administration as well as the NEPCO authority would share their important contact details and email ID for regular communication. NEPCO authority would share the data regarding rainfall and the water level. Awareness and early warning activity would be done at the downstream area before a release of the excess water by the NEPCO authority. DDMA Golaghat would conduct awareness meeting at vulnerable villages in coordination with BDO, Gomarigudi with development blocks, fire and emergency services, SDRF Golaghat. This they did not do. Then NEPCO authority shall inform DDMA and concerned shareholders regarding release of excess water in advance before reaching the spilling level. The Deputy Commissioner Golaghat shall said that regular coordination between DDMA Golaghat and NEPCO authority must be maintained, and if required, field visit or emergency meetings may be held in future.
Lordship may kindly note the point number 5. Point number 5.
Yes,
NEPCO
for the
author-
disaster management. That is what the finding of the district judge is. Information was given.
My lord, no, I am committed. The NEPCO authority shall inform the DDMA and concerned
Yes,
stakeholders
stakeholders.
regarding release of excess water in advance before reaching the spilling level.
Yes, so
That
they
is-
have already informed.
They have
on
informed, but
21st
they have
July.
not released the water. They have not released the water before reaching the spilling level.
That is.
That is
That is
my lord,
what the
important, my lord.
authorities-
That is important, my lord. Because, my lord, because why they have waited till the spilling level, my lord? There is a cause, my lord. There is a reason for waiting till that level, my lord. What happened, my lord? This dam has not been over flooded for last 18 years. The sediments are depositing below the dam for the last 18 years.
That is
To
not
clear, this is one procedure, my lord, to clear the dam when flood comes, my lord. This is called, my lord, the sediment slicing, my lord, sediment slicing in dams. In this process, my lord, the involves the discharging of high flows through the dam during periods of high inflows to the reservoir with the objective of permitting sediment to be transported through the reservoir as rapidly as possible while minimizing sediments. Some previously deposited sediments may be stored and transported by the principal objective is to reduce tapping of incoming sediments rather than to
Yes.
remove previous.
So that the
So
water
this-
holding capacity doesn't reduce.
Water
That
is,
is the purpose.
so these sediments which were deposited for periods of years.
18 years, yes, they
To
were-
release those, to clear those
What-
sediments, they have
what is the
waited.
negligence in that. That is a part of the upkeep of the dam. It has to be done. If the the desedimentation is not done, the dam's capacity will be compromised.
My lord.
That is an activity which is not an offending act.
My lord, that has been done at the, my lord,
They inform the DDMA, your remedy lies against the state authorities, sir. You have made the prayers against the NIPCO. which is not responsible, the report of the district judge is there. Better it is that you file a fresh petition, then, and the district judge has already observed that evaluation process has to be done. Whether you approach the authorities thereafter.
My lord.
We can give you that liberty to seek enforcement of the report. We can very well do that by filing appropriate application to the disaster management authority. We can give you that liberty. But what is the fault of the NIPCO? And when there is an excessive rainfall in the offing, they will have to release the water beforehand. They can't wait. They can't wait for the spillage level to be reached.
They have reached, here in this case, they have waited till reaching of the spillage.
So that is a permissible act.
That is permissible at the risk of the lives of the people.
No, that is why the warning has been given, sir. That is why the warning has been given.
Warning has been given.
So the spillage level release is probably to ensure proper water pressure so that the sedimentation desilting can be done. Nothing wrong in that. There's nothing wrong.
They are saying, my lord, the water level is increasing, my lord.
Yes.
They are saying from, my lord, 23rd that the water level is
21st.
increasing.
21st.
My lord, they have annexed these WhatsApp messages, my lord.
Let us see.
At page 56. First message, my lord. They are saying water shall be released from spillage way if RWL exceeds elevation level of 324 meter on 21st, my lord.
Yes.
Then, my lord.
So they have given the intimation. Now, who is to convey this? They are not the persons concerned.
My lord.
The further conveyance of the message or taking the measures to evacuate the people would be of the district administration. If they have failed, then your remedy lies to prosecute them.
And my lord, the other subject, my lord, on 26th evening, my lord, water has been released. And on
come to page 92, sir. RWL of Doing Reservoir as on 21/7/18 is 320. Water shall be released from the spillway if RWL exceeds 324.
My lord. And that, my lord, water has been released earlier, then they have intimated that the water has been released. That is there, my lord.
That is not the finding of the.
That is not the finding, but their WhatsApp messages says so, my lord. Their WhatsApp messages says so, my lord.
Read.
My lord, I am coming.
They are giving information of
my lord,
every day.
I am coming, my lord, page 63 of their affidavit in opposition.
Let's read the messages, gentlemen.
And my lord, in fact, water has been released on 26th evening.
Yes.
And they have on 27th, my lord.
Come to page 95. Come to page 95.
95 of me.
Yes. What is the date of this message? The 25th July.
25th July.
So they say RWL of so-and-so is 321. We will be issuing a circular tomorrow. That circular is for opening. So day's warning is there.
On
25th, they issued a circular. The water was released on 26th. So there was ample warning.
That circular, my lord, we have received 2 days after, my lord. By the authority, my lord. That I have made, my lord.
That is the responsibility of the state authority.
My lord.
So negligence is obviously.
State authority has received that circular 2 days after, my lord.
No.
Well, that is there, my lord. I have stated, my lord.
Before that, they have given the WhatsApp message. That we are doing it tomorrow.
Regarding the WhatsApp messages, I am saying, my lord, they have released the water on 26th evening.
So the WhatsApp message is on 25th.
28th, they have said that water have been released today. In the morning.
Please come to page 95, sir. The WhatsApp message dated 25th July.
95 we are moved to 95 of which one?
Maybe there is some pagination issue, but it is there in their affidavit. You have it? You're not having.
It will be there. It cannot happen. We have filed and we have a copy.
received copy, UJ Saikia.
my lord, I am.
The only copy has been given to Yamon. Copy has not been given.
Is there any thing?
During the course of the year, it transpires during the course of the hearing that affidavit in opposition filed on behalf of the respondent number so and so, number one, has not been provided to Planet Standing Council, Mr. So and so. Thus, Council, Senior Council, Mr. Mishra shall ensure that this copy is served upon the Standing Council today itself. Let's copy along with the annexures. Re-notified on 28th September. Maybe we can have it earlier, 19th September. Because entire responsibility in that event shifts onto the state. So your clients would also have to approach the authorities with the report of the district judge. You'll have to file the application there. There is a specific procedure provided. Anyway, we'll see.
Their entire pleading, I'll show you a lot. Pleading is that we did not give any warning and all of a sudden we released. That's there in paragraph 9. Oh, paragraph is also 9 twice they have mentioned. But it is their pleaded case. And my lord, we have filed a reply to their, I'm surprised because my junior says,
Receipt, he is right because receipt is only of Petitioners Council.
no, we served it later on. But then why they have not taken the acknowledgement?
Take down the copy of the affidavit has been provided to the Standing Council, Mr. Your good name? DK Sharma today. Give a copy. Objection.
This along with that.
Along with the copy of the
yes,
objection.
So why you have not obtained?
Item number 7.
Give a copy. Yes.
May it please your lordship, my lord, this matter, the petitioners do not want to press it further, my lord.
And counsel for the petitioner raise liberty to withdraw the writ petition, hence the same is withdrawn. Submit that the petitioner is not inclined, petitioners are not inclined to continue with the instant writ petition, hence the writ petition is closed.
Item number 8.
Suo moto.
But for the last order, we are required to file an affidavit bringing on record the training modules. The crime investigation and the law and order that is the segregated. Separation has been done. The notification is there, Mala, that along with the notification, that training module, I have received some instructions very shortly, recently, Mala. I'll bring that on.
What about the other states? Your procedure has been completed?
Mizoram also, we have filed an affidavit long time back on this. But the only thing for Mizoram was like the remaining was the Police Accountability Commission. So that has been notified. The only thing is the right person was like
appointments are not
appointment getting because retired High Court judge or DCPs, so they have shortlisted some, but like they are yet to finalize that.
Senior Government Counsel, Mr. Nath, submit that he has received some fresh instructions and would be bringing the same on record through an affidavit shortly hereafter. Re-notify on 21st September.